Okay, hi everybody. Thank you all for joining us for the first day of the HLEP Symposium, Dynamics in Data Rights and Privacy. We're excited to have you all join me in person as well as over Zoom today. And a huge thanks to Shuhan and Bobby for really bringing the symposium together, as well as Tim Ulrich from the Gunderson team who really helped us plan and create the vision for this symposium. There's a sign-in sheet going around right now, and those are for the free Dream tickets that you guys can pick up at our spring social happening at Whitney's from 7:30 to 9:30 on Thursday. And one more general announcement is that the board applications are open for HLEP, and it's not limited to current members, so please apply. And lastly, thank you to Katie Gu, who's going to be moderating today's panel. Katie is currently the co-president of the Harvard Health Law Society. She's also a student fellow at the Petrie Flom Center for Health Law Policy, Biotechnology, and Bioethics, and is incoming editor-in-chief of the Harvard Journal of Law and Technology. And I'll go ahead and let her introduce our panelists today.
Thanks so much, Grace, for that introduction. Everybody's so excited to introduce our fantastic set of panelists for our first day of the HLEP Symposium. We'll start off with Joe. Joe Cook is the Director of Privacy for regions outside the Asia Pacific, or Ex-APAC, for BeiGene, a global oncology company. He joined BeiGene's Legal and Compliance Department in 2018 and helped found the company's privacy office in 2022. His main responsibility is to lead BeiGene's privacy program, Ex-APAC, with a special focus on the company's European clinical and marketing operations, particularly its general data protection regulation compliance and supporting BeiGene's expansion into new markets. Bless you. Prior to joining the privacy office, he worked as one of BeiGene's attorneys supporting clinical trials for the Ex-APAC region. It is in this capacity that he developed his privacy background, becoming the privacy liaison or unofficial privacy deputy within the legal department. And Christine Savage is the co-chair of Choate's healthcare group, Savage, my apologies, and a member of the government enforcement and compliance group. And she regularly collaborates with a diverse range of healthcare services and life sciences companies to help them satisfy compliance obligations, protect reputations, deliver value, and ultimately facilitate their ability to focus on their patients or customers. Christine's 27 years of experience working internal investigations and managing government inquiries related to healthcare fraud help inform her approach to compliance and risk management projects. As one of the few subject matter experts in the country, Christine is routinely called on to assist academic and clinical research institutions at all stages of the research cycle, from proposal to final closeout. She has led multiple internal reviews related to conflicts of interest, foreign influence, and grants management concerns, and resolved material findings with appropriate government agencies, including the NIH, NSF, OIG, and DOJ. Her work includes helping emerging life sciences companies develop and implement key compliance initiatives to put them on the right footing once they have a viable commercial product. She also collaborates with more established pharma and device companies to assess legal risks related to promotional activities, foundation and charity relationships, open payment requirements, and patient assistance programs. And finally, Stephen Boyd. Stephen is the Assistant Deputy General Counsel at Beth Israel Lahey Health. Stephen specializes in healthcare, including state and federal regulatory-related matters, in hospital and provider licensing, pharmacy, privacy, compliance, billing, and EMR-related matters. Stephen oversees the affiliated hospitals located in the northern region, which include an academic medical center, a hospital specializing in orthopedic care, and 4 community hospitals. Further, Stephen has counseled health systems compliance and integrity departments on privacy breaches, notifications, and the prevention of future breaches, including the development of the health systems revisions to electronic medical record systems to comply with the 21st Century Cures Act. Stephen is also an experienced litigation attorney who has advised the healthcare system on lawsuits by and against government entities and other healthcare organizations and vendors, supervised internal investigations, and counseled clients on medical/professional liability claims. So with that, I would love to turn to a round of individual questions, then a round of group questions, and then finally we'll open it up to audience Q&A at the end. So start with Joe. Joe, could you tell us more about a global overview of the privacy laws in the context of a clinical trial, and what are some of the key differences between the US, EU, and APAC approaches?
So if you have had much background experience in privacy, you'll know that everyone's afraid of GDPR. That is the overarching standard for the globe. That is the strictest law in the world right now. It is also an overarching, very general law. It is not clinical trial specific. And a lot of what we do in privacy, a lot of the challenging pieces is taking those overarching laws and concepts that are frequently written to target Facebook and those sort of large groups, and how do you apply those properly? So we have a few places where you have the overarching laws. GDPR is the biggest one that everyone knows of, covers Europe. We have China has the new PIPO, which we are not exactly sure what it does yet, or exactly what it covers because it's brand new. So they haven't written all the regulations yet. But that's sort of most countries' approach. Most countries apply these sort of large overarching privacy laws, and then we have to figure out how to apply it to our sector. The US so far, at the federal level, has taken a much more concentrated approach. So, for example, if you look at the banking regulations, there's privacy laws written in that they target the specific, they name which types of institutions they apply to. The same thing for HIPAA. HIPAA applies to the doctors, the hospitals, the insurance companies, and the people that help them actually run the patient records. They don't really apply to the pharmaceutical company in the context of how do you run a clinical trial. Instead, we actually have to turn to some of the other areas. So we have to look into sort of good clinical trial practices and other regulations. So GDPR covers all of Europe, but it doesn't say whether or not if I can collect a date of birth, or I can collect race, or I can collect ethnicity as part of the trial. So then we go and look in France, and France has a local regulation specifically for clinical trials, and they say you're allowed to collect this in this circumstance, and in this circumstance you're not. But then you move over to Spain, and they don't. And you actually have to sort of determine what line you want to walk based kind of on risk. You have to do a sort of a global risk assessment. And we know that for GDPR, they have an exception written into the law that says sensitive data you cannot collect, point blank, unless you meet one of these 5 exceptions. And one of those exceptions is research. And so for the clinical trials, we fall under the research exception. That means we can collect the health data, but that doesn't mean that we have carte blanche to collect health data. We still have to meet all of the other regulations. So when we design our privacy program, we try to say, all right, GDPR is the strictest, but Brazil has a similar law, and Turkey does. Australia has a slightly looser law. California now has a law that's similar to GDPR, but not quite. And so if we're going to be looking globally, let's try and make a reasonable, strict standard that we as a company can apply that will limit our risk without us having to have such a nuanced policy that we're looking at every single state and every single province for every single country around the world that we're in. Because once you're at 40 and 50 countries, keeping up with it is impossible.
Second question for you is if you could tell us a little bit more about the recent developments in the law regarding cross-border data transfers.
So this has been my life for the last year, is primarily dealing with cross-border data transfer. And I know that it may seem simplistic to data flows everywhere constantly, right? And as a lawyer working for a pharmaceutical company, do you think I could ever go to the CEO and say, oh, by the way, we can't do that? That doesn't really fly. I would probably lose my job. So we have to figure out a way to make it so that we can do it safely. And so Europe had a recent big change where they had a case called Schrems. And this is a private individual who sued over a treaty between the US and Europe that was allowing the free flow of data. And he said this treaty is insufficient because the US passed a series of anti-terrorism laws after 9/11 that give the government really broad access to be able to subpoena data. And so they completely overturned this treaty and said it's invalid, you can't use this as a basis of transmitting data to the US. So what happened? Every hospital, every ethics committee, every regulatory authority in Europe freaked out because all the data is flowing to the US. And so they're like, well, how can you guarantee it's safe? And so we literally had to go through and write white papers, basically, that we can share, that walk through the different US laws and how, while theoretically you could target this under an anti-terrorism law, the things that we're collecting as part of a clinical trial don't go to the topics that those laws target. So we should, in theory, be outside of them, but no one's ever tested it. No one's ever taken that to court. And then, so we have to have all of these, for every country now in the world that doesn't have GDPR level protection, we have to have one of those sort of white papers for each of our clinical trials and each of our processes. Now, if you switch to China, China used to have a very basic process, which was they had an agency called the HDREC, and they targeted genetics. The Chinese government was really worried about global access to the genetics of their population. And so you had to have special permission and special protections in place to be able to export data related to genetics as part of the trial. But now they have the overarching PIPL that covers all personal data. And so they, interestingly, have taken a different approach. Instead of, in Europe, they put it on the company to be able to defend their approach, and if you get sued or you get inspected, you have to be able to show the documentation. The Chinese government says you have to, particularly if you reach a certain threshold, like if you have 100,000 patients' data, then once you hit that threshold, you're now subject to direct oversight where you have to submit filings to the Chinese government detailing all the data you collect and what you're doing with it, and every single entity you're sharing it with, and then every single thing you have in place to defend or to protect the data. And so they've taken a completely different, now need government permission for all data that comes out, not just genetic data.
So Christine, over to you. Could you tell us a little bit more about the biggest privacy challenges that healthcare startups face when dealing with data?
Yeah, so I think the biggest challenge is sort of where privacy.
Sorry, Stephen, I think this is actually for Christine.
Oh, sorry.
Yeah, no
Sorry, Christine. I'm like, I don't remember that question being on my list, but I'm happy to join in.
You were ready to go. So a few things with startups. So in my practice, we spend a fair amount of time with either venture-backed companies or companies that are a little bit further along in the process. A private equity firm is, investing in a business that, if it's a pharmaceutical company, isn't yet commercial. They've got some, things in the hopper that, may eventually become commercial. They may try to sell off those assets before they become commercial. But at the sort of the infancy of a company, when they've got, say, fewer than 50, fewer than 100 employees, and they're really sort of at a more conceptual stage, the types of privacy issues that come up fall into 3 or 4 buckets. So one is really working with a company to help understand the value of the data that they have, and whether they, at the end of the day, want to be a company that builds or sells or services something, or whether they really want to be a data mining or data leveraging company. And you can't always do both of those well. Sometimes you have to pick a lane and partner with somebody else. And so how you treat the data, what you tell customers, if you're doing research and getting information from people. On day one, you may be telling people, if you give me this information, it will never be shared with anyone. Or you may say it will only be shared with people for a particular purpose. And then 3 years later, 5 years later, somebody else comes in, they invest in your business, they buy your business, but they want to or think they have the right to use the data for something completely different. And you may not be able to now go back to the people that you originally got the data from and get their okay to use it for something else. And there are ways around that, but something that we work with startup companies a lot on is think really broadly about how you might want to use this data, because what you think you want to do now may be very different from what you ultimately decide you want to do 2 to 3 years from now, and you don't want to hamstring yourself. The second is really trying to impress upon young companies the need to create an infrastructure for regulatory compliance. So encrypting your data, both in transit and at rest, having role-based limitations. So when you're at a startup company, everyone does everything at some point in time. That doesn't mean that everybody needs access to every piece of data. And so I've certainly had smaller companies that I've worked with where they were doing, lab-developed tests, so not FDA-approved testing. They had a very rich data set of genetic-related data. They had salespeople going out to institutions, and they had very detailed information about how many tests were in process at particular medical centers, when they expected results back, being able to identify particular genetic anomalies. And you could have a sales rep in Oklahoma who had access to sort of the progress of the testing for every single patient across the country. And lo and behold, like the guy in Oklahoma, loses his laptop, like leaves it in a car, it gets stolen out of the car. And when we go to talk to the company and we say, okay, but this person probably only has any data related to people in his particular sales territory, and what we're told is, oh no, there's an Excel spreadsheet that has everybody everywhere. And luckily we were able to, determine that there was no breach. We were able to wipe the computer remotely and everything was fine. But impressing upon people that there are really good reasons to limit who has access to data, and the time to figure those things out is at the beginning, because it's very hard to put it back in a smaller box later down the road. Third is really understanding the limits of what you can do with the data, depending on how you obtained it and how you want to use it. So for genetic data, along the lines that Joe was talking about, even within the United States, there are a wide smattering of state laws that require either a different level of consent, a more detailed level of consent if you're going to gather genetic information. If you're going to share that information, then occurs at the federal level. And so if you go to a lab to get genetic testing, there are often like pages and pages of addenda, because what somebody needs to sign in Illinois or in Nevada is different than what they need to sign if they're in Massachusetts. And you may be restricted in terms of what you're able to do with the data depending on where you're gathering it. I think most people in the United States are familiar with HIPAA, because you go to a doctor's office and somebody makes you sign a form. They give you a notice of privacy practices telling you generally what can or cannot happen. For people with substance use disorder, there's a whole separate regulatory scheme called Part 2, and that carries with it criminal penalties if you use that information inappropriately. And basically it's a strict liability statute. Like if somebody gets it that isn't supposed to get it, even if they don't do anything bad with it, if they delete it, et cetera, it can be a really big problem. And so there are a number of startup companies, and I think particularly during the pandemic, there was sort of a rush of telehealth businesses in the substance use disorder space for really good reasons. If people couldn't get to a meeting, or if people otherwise wouldn't have had access to get Suboxone or other treatment, having that available by telehealth was a really great idea. A lot of the companies doing that, however, did not have sort of data privacy policies or other infrastructure in place to be able to really handle how they were using or sharing that information. And I think there will be likely litigation down the road related to that. And the last thing I'd say on the startup piece of things is, at the startup stage is also a good time to start having discussions about the distinction between what is legal, what is ethical, what can be made operational, or where you're going to have implementation risk, or execution risk. So I can have the best policy in the world, but if nobody reads it, or if nobody can figure out how to use it, is it going to be a paper tiger kind of policy that isn't going to get me anywhere at the end of the day, and I'm not going to be able to use to defend what the company has done. And then thinking about reputational risk. So you can do something that's perfectly legal, but from a reputational perspective can really tank a company, and sort of having those discussions on the privacy side at the beginning is smart.
Could you tell us more about how healthcare providers and tech companies are adjusting to recent agency action by HHS and FTC involving ad tech?
Yeah, so ad tech or web tracking tools have been in the press quite a lot recently. So a series of articles came out in an online publication called The Markup in 2022, raising concerns that first hospitals and then telehealth businesses in particular were using, either the metapixel through Facebook and Meta or Google Analytics and tags in a way that if you got onto, a telehealth business website and say you were searching for a mental health clinician who could, take care of you in Illinois, sort of via video conference, that the fact that you filled out information that you were interested in obtaining those services, if there is a tag or ad tech placed on that page, would relay back, either to your browser or both through the browser to third-party social media companies, information that would make you identifiable. So if you, and I know most of you are young enough that you're probably, none of you are on Facebook anymore, you're on other things, but if you're on Insta, sort of same problem. Effectively, you have a C user ID. And so every time that you remain logged into Facebook and now you're off doing something else somewhere else, there is still information so that if there is a metapixel, it links your C user ID from Facebook or Instagram to whatever else it is that you're searching. And so they are able to create profiles. So they may figure out that somebody who goes to Harvard Law School and is in their mid to late 20s is likely to have an income in a particular range within the next 3 to 5 years, or they may be somebody who on the weekends likes to go to particular types of speaker series or certain types of bars. And you're then going to get fed ads related to that profile. And so in this particular instance, the concern is if you go to that telehealth website saying, I want more information about finding a therapist who can help me with my clinical depression and ADHD, and that's going back to Facebook, and that's going back to Google, is that something that you expected to happen? Is that something that you think legally should happen? And so in December, the Office for Civil Rights within Health and Human Services said, full stop, wait a minute, and mind you, HIPAA's been in place for over 20 years. This is the first time that Health and Human Services has commented on certain aspects of HIPAA. And they really took most of the industry, I think, by surprise in how broad their view is about what you do on a public website may implicate HIPAA. So if I get onto a hospital website and I search, find me a doctor who treats colon cancer within 15 miles of the city of Boston. Health and Human Services is now taking the viewpoint that if there is a tag that relays that information back to a third party, then the hospital better have what's called a business associate agreement in place that then limits what that third party can do with the information. And really, they're only supposed to be using that information for purposes that relate back to the hospital. And that's not historically how the industry has treated it. That's not how the lawyers who advise those institutions had ever really thought about this. And so there has been a huge wave of class action litigation. The first wave sort of in 2019, there were a couple of cases around the country. Those, for the most part, settled out. And judges at that time took the position of, yeah, this protected health information thing, that's kind of a red herring here. It's really about whether or not there was a breach of contract or whether the privacy policy was legit, or perhaps there were Wiretap Act violations. So many states have their own wiretap statutes. Massachusetts, among probably a dozen others, require two-party consent. So when we think about this in the normal case, it's if somebody's going to record your phone call with somebody, they have to ask you first if you're in Massachusetts. If you're in New York, which is a one-party consent state, nobody needs to ask you. So any phone call you have while you're in the state of New York, somebody could be recording it, and you should probably expect that maybe somebody is. But in Massachusetts, that's not permitted. So the question now is whether the Wiretap Act includes the interception of communications where you type a search on a website, there's now a communication back to the browser, and now through the tag back to a third party. Is that, is the tag causing an interception of the communication that you think you're only having with a hospital's website or somebody else's website? And there are statutory penalties that add up unbelievably quickly under these statutes. So it can be $100 for each instance or $1,000 per individual. So if you think about an insurance company that insures millions of people in a particular state, those dollars add up really quickly. So we've got HHS looking at it. We've got class action plaintiffs' lawyers who are filing suits. There's one firm that pretty reliably now for the last 2 months, every other Friday, they file a lawsuit against somebody else in the state of Massachusetts. And so we now track sort of where are they going next. The Federal Trade Commission has jumped in on this within the last couple of months. There have been 2 large settlements with companies. One, a company called GoodRx, which for people in the life sciences space, they help provide pharmaceutical discounts, coupons, help people find programs that will help them get drugs at a lower cost. They are not a covered entity. The pharma companies aren't covered entities, so they're not governed by HIPAA, but they are subject to the Federal Trade Commission's 2009 Health Data Breach Notification Rule, which until 2023 had never been enforced. And now all of a sudden people are taking a look at that. One of the reasons for this sort of uptick in enforcement, less on the class action side, but from a regulatory perspective, actually has to do with the Dobbs decision. And so there's a big concern. The president mentioned it in his State of the Union address. It's in the National Cybersecurity Strategy document that was issued within the last month. A real concern that people now have access to or can purchase data that may indicate that a woman has sought reproductive health care services, that she's using a menstrual cycle tracker app. There may be geolocation data where somebody has placed a tag so that if your phone gets within 100 yards of an abortion clinic, something goes off. It may feed you an ad from an anti-abortion agency in the hopes that that's going to get you to turn around. And those types of technologies are used for all different kinds of reasons. But I think the concern that they could be used as a weapon against women seeking healthcare services is driving a lot of the HHS, FTC, White House sort of pronouncements in this area, and is really going to be an area to watch.
Thank you so much, Christine. Over to our last panelist, Stephen. Stephen, could you speak more about the rise of interoperability in hospital systems and their privacy implications?
Thank you. So interoperability in healthcare, especially in hospitals, is sort of a new phase of healthcare, right? So for years and years, we had a very paternalistic system, right? We had a closed loop where you'd go visit a local hospital, they'd have your medical record, they'd house it locally, or maybe they had an electronic medical record system, but it was sort of housed within its own healthcare system. They weren't sharing information in a very user-friendly way. You go to a hospital in California, go to a hospital in Massachusetts, they weren't necessarily talking to each other, right? They were sort of separate, siloed institutions, and that's the way they operated for years and years. Sort of over time, as systems got bigger, and I don't know if you folks have heard of some of these large electronic health record systems like Epic or Cerner, they got larger and larger, and they increased their capabilities of being able to talk to each other. So Epic, for instance, if you go to a hospital in California, go to a hospital in Massachusetts, has a way of connecting that patient. They map it to the same individual patient, visited a California hospital, visited a Massachusetts hospital, and they can sort of let those hospitals connect to each other and be able to share information. That's net positive, right? I think everyone would say that it's good for healthcare, it's good for the patient, you get continuity of prior care, et cetera. But at the time, Epic wasn't necessarily talking to Cerner or talking to Meditech, another sort of electronic health record system. So that wasn't very user-friendly for both clinicians and for patients because these systems weren't actually communicating to each other in a thoughtful way. Or when they were communicating, you were getting bits and pieces of information which wasn't really helpful to a patient. So what ended up happening is the Cures Act and several of the laws and regulations at the federal level sort of kept pushing forward the concept of interoperability being the stated intention of the federal government. They wanted us to be sharing more information. They want us to be more of an open system where the patient owns the record. It's not Beth Israel Lahey Health owns your record and you're just simply a user who came in as a patient. They want the patient to be the actual owner of this record and to be able to have it go with them. So no matter where you go to a hospital across the street, you go to your local hospital, you go on vacation, that all these systems are capable of communicating with each other in a much more patient-centric way that allowed interoperability. They also wanted you as a patient to be able to take that record that sits in an electronic health record and then bring it elsewhere. So bring it to like a third-party app. So maybe you have a Fitbit or you use some type of third-party vendor-developed app that allows you to sort of take your medical record and make use of the data that's in there for fitness reasons, or you're tracking a given illness that you've got. They wanted a system that allowed you to sort of take your own record, bring it elsewhere, and to be able to sort of have these things all connect and talk in a very sort of smart way. That all sounds great, except if you work in a hospital system where you've been told for years you have HIPAA, you have various privacy laws. Massachusetts has an even stricter privacy law. We're not supposed to be sharing any private information with any third party. So you have people now saying, well, I thought I was told for years I wasn't supposed to be sharing information with the outside world. Now you're telling me everyone is going to be speaking. It's true, but you're only, there are exceptions to these laws about interoperability, and we certainly, if there's a privacy law that says we can't share it, we're not supposed to share it. But how you design a very smart system to know in real time what's the private sensitive information versus the stuff that we should be sharing and not what they call information blocking is not always very clear. And it's definitely not clear to the individual physician who's seeing you, who's saying, geez, if I write a note like this and a patient were to see this note, they're probably never going to come back here and get care again because they're the access they're getting to their own note that I'm putting in the record. That's a lot of information that a patient might use to not see me again, not follow up on the care I'm recommending, or otherwise just be really scared to get care in general, which is not the goal. We want to have the patient get better. So that's not helping it. Or there could be something like you're a minor and you're going to see a doctor about a reproductive issue and you're 16 years old. Well, it's great that we want all these systems to talk, but maybe you don't want your parent to see the fact you went to a doctor about a reproductive issue and your parent has very different positions that you do on a given point. Well, if these systems are really good at talking and they're all talking in real time, it's not terribly helpful if your parent's going to see that information that you as a patient deem very sensitive. It might not be something that you have an absolute ability to know in real time. Block this, I'll let this go and sort of promote the interoperability goals of the sort of laws and the regs that exist. So it's a real challenge at the provider level to be able to navigate these sort of patient-centric goals that a hospital has, to treat the patient, make the patient get better, share as much information as is useful and productive and allows us to make sure the patient adheres to the plan, while at the same time not scaring patients with too much information, accidentally sharing too much information, or sharing it with an untrusted third-party vendor who might then have the information go to places we've never intended it to go, and then it's out there in the dark web and we're never getting it back. And because of all those things, it's a little difficult being on my end of the things, being in-house at a healthcare organization, trying to navigate protecting patient privacy while honoring the stated goal of having an open medical record that really is a patient medical record that they own and they can take with them without looking like you're being too paternalistic. And that's the sort of classic lawyer discussion I have with clients internally is how do we do both things at the same time, protect the patient while at the same time comply with the stated goals of interoperability.
What policy priorities impacting patient privacy are hospitals currently advocating for?
So Christine actually mentioned one of them that we're really strongly in favor of, which is Part 2. So Part 2 is got a lot of penalties that come with it. So this is substance abuse treatment record. You can imagine why you'd want penalties on substance abuse treatment record information sharing to exist. That's really sensitive information that people wouldn't seek treatment if they knew the outside world had easy access to. But what do you do if you're in Beth Israel Lahey Health, where we operate Part 2 facilities, hospitals, primary care practices, that all need to talk to be able to deliver the most patient-centric type of care, right? A primary care physician would probably need to know what's happening with that Part 2 provider, medication they're prescribing, medication adherence by the patient in that program, how long they've had this substance abuse problem they've been seeking treatment for. You can imagine that'd be really helpful to a primary care physician to know. But the way the system is set up, it's almost like it's siloing Part 2 information here, primary care physician or general healthcare information here, and there's ways the two can share, and we can get consent and things like that. But what do you do if there isn't an express consent to be able to share those things? How do you deliver really good patient-centric care while at the same time not having a document in place that shows that the patient definitely wants you to share that information? It's a real challenge. It's a challenge when you're on both sides of the aisle, like we are operating Part 2 programs, but also operating hospitals and primary care practices and things like that. There's some proposed rules coming that would make this a lot more user-friendly, and that's, I think, a good thing. So this is something we're advocating for, is to say, listen, we understand HIV, Part 2, reproductive rights. We totally understand why some of this stuff is as sensitive as it is, and the penalty should be big, because it's really sensitive. But we have to be smart about, in the real-world application, how do you actually take that really sensitive information ensure what's in the best interest of the patient. That's a hard one to define, but it could be more user-friendly than it is. So that's something we're really advocating for at the moment. I would say as far as other advocacy that we're focusing on, we talked about reproductive rights in minors. The law is not great in this space where a parent has a technical right to get their child's record because the child's still a minor. But the subject of what the child is seeking treatment for is extremely sensitive. It's reproductive rights, it's STD testing, it's behavioral health conversations that are happening. And the intersection between caring for that patient who happens to be a minor and keeping that extremely sensitive while honoring the fact that they are someone's child and they are responsible for that child, and to make the best decisions they can for their child, they need a complete picture of what type of medical care the child is getting. How do you balance those two things? And more clarity on the privacy rights of the minors versus the privacy rights of the parents and the accessibility of the parents is something we would love more clarity on, because with the Dobbs decision, we've only seen more and more of this where it's causing headaches for providers to know how much to put in a note now when it's a 15-year-old child coming for a pregnancy test, and being afraid that what's going to happen if a parent sees the note I'm treating the child. That's my stated goal, is to be as patient-centric as I can for that patient in front of me. But I know very well the person who's going to read this note is the 35-year-old parent of this child. And how do you balance those two interests?
Thank you, Stephen. Before we open it up for audience Q&A, one group question for the panel. What advice do you have for law students interested in healthcare and privacy? And we can go around, maybe same order. Joe, if you want to take this one.
So I always tell everyone I had a very convoluted route to my current career. And I'm currently in-house counsel working in an area that I find particularly interesting in a company that I absolutely love. And so I am as happy as I've ever been in my life, in my career right now. But it took a long time to get there. I went to law school. I had this idea in mind. I was going to do environmental policy. I was a scientist to begin with. I wanted to do environmental policy. I should have listened to the omens when I went to law school, and I picked a law school that had this great environmental policy program. And when I got there, the person who led it had been hired away, and they canceled all the classes. So I, in law school, never took an environmental policy class. But after law school, I still tried and went off and did government, and was working on a political campaign to try and get myself into the White House under Gore, and then he lost. So I ended up finding that I had a great challenge, because law school is designed to set you up on your first footing. And so by missing that window, I was struggling to figure out how to get myself back into like the traditional path. So it took a while, and I finally worked my way into a law firm setting. And I took the first one that I could get, basically. And it was a patent litigation job. And with my science background in that, it made sense. You know, I understood all the science. I'd done the tests, I'd run the genetics. I loved that piece of it. And then I realized, and I did this for almost 10 years, I realized that I loved all the lead up to court, but when it came to all of the filings and the types of arguments that were there, and the things you were fighting over that seemed to be completely not relevant to the scientific question, I didn't really enjoy that part. After a few years of that, I was finding the trial part to be much more stressful. And so I decided I was going to transition. And so I went off to, decided, jump ship, and everyone was like, oh, you're a litigator, you're a litigator, you're a litigator. No. I have all this experience, let me use it to help you keep from going to trial. And I made my way into in-house. And I will say it was night and day for me for the work-life balance. I mean, even at a startup company, working at a law firm, there's as an early associate, in the big cities, you're going to be working 60, 80-hour weeks easily. Some trial prep weeks, it's 120 hours. In-house, a busy week for me is 50, 60. And so that made a huge difference for me. It's just the work-life balance, the subject matter. But not everyone knows what they want to do going out there. And so I do recommend research bounce around a little bit, look at different things, but don't be afraid to say, this isn't working, I'm gonna drop out, I'm gonna not stop being a lawyer. Maybe it's not working because you're just not in the right spot yet. And so I do recommend being open to opportunities and exploring and seeing what part of this fits your personal goals here.
So I've been at the same firm for 27 years, so I'm not in a position to talk to you about sort of job jumping. Although I will say the work that I do now is really, really different from the work that I did when I started out as a lawyer. And so I think, sort of in alignment with what Joe was just saying, you can have an idea of what you're going to do when you get out, and what you're going to do over the course of your career is going to change multiple times over in ways that you can't really predict. For me, if you're interested in healthcare law and you're interested in privacy, there are a few sort of subject matter areas that it would be a good idea, to the extent that you've got the flexibility to do it, take administrative law, because regardless of whether it's environmental or healthcare or labor and employment or whatever it is, like the ability to understand the difference between statutes, regulations, guidance documents, how those things are interpreted, dealing with administrative agencies and what those processes look like, whether it's sort of administrative appeals and the like, will definitely benefit you regardless of sort of where you end up or what particular subject matter you're looking at. I think understanding the technology, so whether there's a cybersecurity and data privacy course at the law school or frankly anywhere within Harvard University. I don't know what the policies are now at the law school, but when I was here, they were pretty liberal in terms of your ability to take courses, throughout the university system. And, particularly during your third year, like if there's something that subject matter wise really resonates with you, like find an opportunity to get there. There's plenty of shuttles and the T and everything else to sort of get you from one place to another. And you're going to meet people who come at these issues with a very different perspective, which can also be extremely helpful. If you're more early in your legal career looking for, internship opportunities, research opportunities with faculty members who are, working in an area of particular interest. Particularly the first summer, like working at a law firm is not the end all be all. I was a research assistant for a faculty member who at the time was teaching at the law school, the med school, and the School of Public Health. He then left and went on to become the chief medical officer at Aetna and then at CVS, and then I think helped orchestrate the combination of those two entities. But I worked for him and got paid, which for me was better than working on a journal. So, looking for opportunities outside of the university is also a good idea. But I think just, anything you can do to, I wouldn't be paranoid about I'm not the world's greatest subject matter expert. It's really sort of learning more about the thought process that goes into helping clients through these types of problems that I think is really the most useful. And that can happen through an internship, through research, through coursework.
Yeah, I would echo everything that Joe and Christine said. I mean, if you don't know the substance as well as you need to on a given issue, I have Christine that I can go and hire. I have a case right now where I went to Christine about, where it was something we needed an outside attorney who had a level of specialty that no one in-house is ever going to have. We would hire someone like Christine's firm to be able to represent us in a case like that, right? There's always law firms that can do that. My advice, other than what's been said already, is find something you're passionate about. I worked at a law firm for 13 years. It was great. It was a nice paycheck, but at the end of the day, it wasn't a mission-driven job, right? It was a job, and it was a good job to have, and it was steady. But then I went in-house at a nonprofit healthcare system, and then 4 years later, COVID hits. And I discovered the importance of actually having a job that was mission-driven, that had an intention behind it that was bigger than getting a paycheck. It was sort of helping people, and the worldwide pandemic was sort of disrupting people's lives. I was literally doing something to help. I was opening a vaccine clinic. I was finding a way to get vaccines to patients as quickly as possible and as nimbly as possible and complying with laws. It was the most stressful 3 years I could possibly imagine, but having an actual like mission-driven company that I was working for made those 90-hour weeks a lot more tolerable. And in fact, I didn't mind working on weekends. I didn't mind working late into the night because I finally found something that was sort of enabling me to feel like I was actually doing something, moving the ball forward, not shifting papers from one side of a table to the other like I felt at a law firm. And that's not something I think I realized until I spent 13 years at a firm and then spent 8 years in-house. A lot of you are going to find it's kind of difficult to go in-house right out of law school. Like some of the jobs, you really need that real-world U.S. Attorney's office or a law firm before you can really contribute in an in-house environment. But when you're ready and when's the time, it does make a big difference to actually have a job that is moving the needle forward in a positive way. And I'd sort of end with the stuff from the Dobbs decision, seeing how I know countless people in my organization that have been spending months figuring out how to respond to a case like that, how to respond to the case in Texas that's waiting for a decision right now, and what's the next step? What is our organization going to do if reproductive rights have another sort of turn because of a case coming out of the court in Texas? That type of mission-driven organization makes getting up and going to that type of job a lot easier. So the more hours that might exist on my schedule, it's easier to get up in the morning and do them if I know we're actually helping people's lives, we're helping people feel better, we're helping people get better. It's just an easier job to go to every day. Not for everyone, but if that's your priority, it is a lot easier to get up in the morning.
And if folks don't know about the Texas litigation that Stephen was referencing, that's a challenge to access for medication abortion across the country. So trying to challenge the original FDA approval of mifepristone, which is pretty scary. And I imagine we're all waiting eagerly to see what happens from that. So with that, a big round of applause for our panelists. And we'd be happy to take any questions from the audience.
Hi, I'm a 1L who's interested in entering healthcare eventually in some form or another. I'm interested in your perspective on like picking a like maybe niche of healthcare to enter first. I know there's like pharma healthcare services and like med tech, and I guess the nature of being a lawyer is like pretty generalist. But if you had any suggestions on navigating or deciding which niche or like vertical of healthcare to enter at the beginning.
So I would default back to what Stephen was saying is find what you're passionate about. I think the beauty of being a healthcare lawyer is you can be any kind of lawyer and be a healthcare lawyer. So you can be an M&A transactional lawyer. You can be a patent lawyer working for a pharmaceutical company in oncology or genetics, rare diseases. So the world is your oyster. I think you just need to find out sort of what type of lawyering do you want to do and how to fit that into, fortunately, an industry that makes up a third of our GDP. So for me, I wrote my third year paper when I was here about conflicts of interest in industry-sponsored medical research and looking at how financial incentives might cause people to structure trials in a way that were disingenuous or might cause problems. And looking at it through the lens of different ways that the government could attack that problem, which included using sort of fraud and abuse laws. I was fortunate enough to end up at a firm where a year and a half in, I ended up on a 6-year case that was looking at kickbacks and False Claims Act and a whole host of other things for a dialysis services company. That was luck. I now spend a lot of my time dealing with conflicts of interest in industry-sponsored research, and so I feel like I've sort of come full circle of like the thing that I wrote about almost 30 years ago is now what I'm spending my time on, which is great. But that was something that really resonated with me then, and that sort of drove the type of firm that I looked for, like who does the type of work that I would like to do, knowing that work, again, is going to change, but who's thinking about these issues in the same way that I am, who are thought leaders on these particular issues, and being really strategic at the firms that I looked at, in terms of finding that first job to try and set me up for whatever might come next. And it just so happens that I landed someplace that I've never wanted to leave. And at this point in my career, I don't envision that I will leave, at least not for another lawyer job, maybe do something else down the road. But, if you like doing deals or you want to help people build something, maybe you want to be a healthcare patent-related lawyer or a transactional lawyer. If you want to help ensure that companies have the freedom to do things that they should be able to do in an environment where regulators may be heavy-handed, maybe you want to go into litigation. So there's lots of opportunities.
Hi, I'm a LM student from China, and I used to be a food and drug regulatory lawyer before coming to HLS, so I was very interested in your previous talk about the genetic data cross-border transfer in different jurisdictions. So my question for this is that what do you think are the major differences between different major jurisdictions such as China and the US and EU in terms of their restrictions and systems in preventing the misuse of genetic data, and what are the systems that are in place regarding cross-border data transfer? And do you think that the Chinese system, the HGR, Human Genetic Resources System, their currently use are too burdensome for big pharma and biotech companies?
So I can start with the last part of that first. A lot of the privacy regulations that we're seeing are becoming too burdensome and are interfering with flow of data that is necessary to develop new drugs. And the FDA has issued warnings on it, industry's issued warnings on it. The UK has just come about with a draft that's going to actually loosen the regulations. Europe's looking at a draft that's going to strengthen or tighten the regulations even further. Some of the governments are hearing us, some of them aren't. With China's new PIPL, they set up a completely new agency now, and we're not sure where they're going to go with it. So we're hoping that they'll take a balanced approach, but we're not positive. The initial filings were overwhelming. It was like 6 months of work with daily meetings with outside attorneys to just do the initial filings for them to tell us whether or not we have to do anything else. And they haven't, we just did them because they didn't start accepting the filings until basically February. And so we're waiting to hear what they're going to do. We are expecting them to come back and say, well, you need to take these mitigation measures to try and to protect things further. That said, the biggest thing that we try and focus on right now for protecting the company just generally is the consent process, the consent and notice process that are part of the trials. If we haven't been able to clearly say, this is exactly what we're using the data for, this is exactly why we want it, this is the scientific rationale, then it's really hard to make sure that we've stayed within the rules. Are what we're doing with the data now and what we want to do with it in the future going to be covered? We want to make sure we capture that to give us the flexibility and to give us the protection, because under most of the laws, as long as you have clear consent from the patient, most other things are, as long as you've taken reasonable measures, most other things are fine. The biggest issue is security, but that's not really lawyers. IT security is IT. They come with me with questions all the time, and I'm like, you tell me, I have no idea what the difference is between ISO 2007 and 2007-1 and whatever. That's their job. So our job is more on how have we clearly said what we want to do with the data, have we clearly captured that. And for the process for the company, for the transfers, there's a whole series of different steps. And so we have intercompany agreements that cover the transfer data within the company. We have special contracts we have to have in place with all the vendors. And so everyone's releasing their own standard contractual clauses, not negotiable for their country. And now we have 14 of them that we have to have each vendor sign. It's getting a little crazy. So we've tried to say, all right, we're going to take this standard and we're going to have in our contract, for Argentina, we modify it for this. For Brazil, we modify it for this. And so we have one to sign and then another contract that lays out at a table all the variations by country. Because it's like, if all 40 of the countries that I'm working in right now have their own clause, I would never be able to get the vendors to sign them all. And they have conflicting pieces in them, so there's no way we could get everyone to comply with every piece of them and not. There's a conflict built into the process here. So we have to try and thread the middle as best we can, and that's part of the fun is, have we learned enough about all the different major laws and to design a path that will protect us against 95% of what our risk. Because there's no way in a global company that you can be perfectly compliant with every law globally.
Hi, thank you so much for being here. I was just wondering if you could expand on how like healthcare data privacy fits into overall data privacy policy and how you view that going forward. Like, will it be a forerunner? Are there like big issues with conflating the two?
Yeah, I mean, I think as interoperability and data gets bigger, I think they can't help but intersect, and they're difficult to divorce. You know, what is PII versus what is PHI under HIPAA, and it's not always necessarily clear. You know, where we talk about multiple different laws and sort of regulations now we're sort of infringing upon, because just think when you go to the hospital, you're getting billing information, credit card information, you're getting protected health information under HIPAA. You're getting, you know, sort of other sensitive, no matter where you touch a healthcare system, you're getting different pieces of sensitive information, including, like I said, payment information and Social Security, that then expands the scope of what you can have go wrong. And then beyond that, you're using, most of the time, external vendors to manage a lot of portions of your system, whether it be billing or management of certain operations. I think it's only going to become a bigger problem because as we sort of get more data, there's just more and more touch points of privacy laws that can be sort of implicated. It's not just HIPAA anymore. It used to be we could just focus on the healthcare specific laws. Unfortunately, the bigger the data, the more, you know, bigger the risk now across the board.
And I don't know if the other panelists feel this way, but I honestly, the current draft I'm not particularly happy with, but I honestly look forward to the idea of there actually being a federal law at some point that's an overarching federal privacy law, because just as difficult as it is to meet all the country variations, once we start saying we're going to have 50 state variations, it's just going to become an even greater nightmare for us to try and meet all the different requirements. So I'm hoping that they eventually have a good overarching privacy law that will help differentiate the different areas and that, but we'll see.
Yeah, and just to highlight what Joe said, I had a case recently where there was something that was disclosable to the Attorney General in one New England state and then nothing to be done in another New England state. It made no sense with the exact same fact pattern where there's a group of 10 people impacted. One person resulted in no notice at all. The other one resulted in telling the person plus telling the Attorney General. So that's just an impossible world to navigate with 50 different answers to that question.
Or even worse, there are some states where you have to notify the person that there was a breach, but you can't tell them in the letter any of the specifics about what was breached. And then in another state, you have to say exactly what was covered in the breach. So you end up in Massachusetts writing a letter that has one level of detail, and in either New Hampshire or Connecticut or somewhere else, you end up with something that looks completely different, even though it happened as part of the same exact incident. So that if you've got your cousin who lives across the border, they get a letter and they've got all the detail, and you're stuck at home going like, now you've got to get on the phone and talk to somebody to get more information. It's completely untenable, and particularly when you do work for companies that have patients nationally or internationally. So like Lahey. If they have a data breach, it doesn't just relate to people in Massachusetts. People come here from abroad. People come here from 50 states, or the Dana-Farber or Mass General, like any of those institutions. If they have a breach, they've got to look at all 50 states, and the letter that they have to write may be different. The timeline within which they have to respond is different, and it's a real morass. So having something federal that would just say, here's the standard, and if you meet this standard, you will have satisfied anything else that exists would be perfect.
I feel like that's like the Oscars when the commercial starts running.
The music started.